the full screen. Click to record the full screen. All right, it looks like we are in business. Testing 1, 2, 3. 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 Hi everyone, this is Mike DeBliss. I'm going to be presenting today on anatomy of a civil tax controversy. This is an area that I am very passionate about. I maintain a civil tax controversy practice, and there's never a dull moment when it comes to civil tax controversies, whether you're dealing with the IRS and the Appeals Division, or if you are in tax court. So I'm excited to share this presentation with you today. A little bit about me. I am a trial lawyer. I got my start in the Office of the Public Defender after graduating from law school, and was able to cut my teeth on some really difficult trials and criminal cases right out of law school. And that has made me a very zealous advocate and a passionate attorney when it comes to representing and defending the rights of those who are less fortunate. I'm also an actor who is trained at a conservatory in New York City. I'm proud to say that I have appeared in some off-Broadway productions, and I'm looking forward to doing some on-camera work in the not-too-distant future. I've also done a lot of writing in the area of tax law, and a lot of my articles have been published in various tax publications. And then on the side, when I get some time, I do enjoy running half marathons, and I do hope to build up to a full marathon one day with the goal to do the New York City Marathon. So just a little bit of background information on me. So let's jump into this. The way I like to describe civil tax controversies is as there being a certain rhythm to the audit process, and to some it can be a very scary beat. And I don't mean that in an ominous way, but it is very unnerving and unsettling to receive an examination notice from the IRS. And sometimes the very first thing that happens is that the client begins to panic and begins to make some knee-jerk responses that are not necessarily good for them in that moment. So it's very important to counsel the client that if they do receive an examination or audit notice, to stay calm and stay cool, and to reach out for their accountant and perhaps for a tax attorney to help shepherd them through the process. It's much easier to go through this with a good advisor, such as an accountant or an attorney. So what I've done is I've reduced civil tax controversies to steps. They don't always follow these steps. However, the ones that I've drawn out for you are pretty much well settled as the ones that civil tax controversies do go through, and there are some deviations, but these generally encompass what happens when civil tax controversies begin. So with step one, the IRS conducts a tax audit. Basically, a tax audit is an examination of your income and expenses to ensure that you correctly reported your tax liability. All types of tax returns are subject to audit, including income, business, estate, and gift tax returns. In step two, the taxpayer receives what's called a 30-day letter. And so let me just back up for a second. The examination can result in three possible determinations. The first is an increase to the taxpayer's liability. The second is a decrease to the taxpayer's liability. And the third is no change whatsoever to the taxpayer's liability. So here, let's suppose that upon completion of the exam, the revenue agent determines that a deficiency exists. We hear this term deficiency thrown about, and it's very important that we define it with accuracy because the IRS has a very specific definition for a tax deficiency. It's not very complicated. It's simply defined as a taxpayer's correct liability as determined by the IRS less the amount that the taxpayer reported on the return. So again, when we deal with deficiency, we want to be very precise in how we define that term. And it is defined as the taxpayer's correct liability as the IRS determined it to be less the amount reported on the return. And so going back to this hypothetical, let's suppose that the revenue agent determines that a deficiency does exist. Assuming that there is a deficiency, the agent will prepare what's called a revenue agent report. It's sometimes reduced to the acronym RAR. Included within the RAR is a cover letter and a settlement agreement. So it basically presupposes or basically provides the taxpayer with the opportunity to simply sign and agree with the revenue agent's findings of the deficiency and mail in the amount that the taxpayer owes. Now, of course, there will be those times when the taxpayer disagrees. So what happens when a taxpayer disagrees with the revenue agent's findings? Well, the taxpayer does have rights. And one of those rights is that the taxpayer may request a conference with the IRS Appeals Division. The IRS Appeals Division is analogous or similar to mediation in civil cases. And what it is basically a neutral person from the IRS Appeals Division that hears the IRS's version and hears the taxpayer's version. And based on hearing the arguments made by both sides, the IRS appeals officer makes a decision on whether to affirm the revenue agent's findings of a deficiency or whether to side with the taxpayer and find that no deficiency exists. So that's kind of a thumbnail sketch on IRS appeals. Don't be misled or confused into thinking that appeals, because you see the word appeals, that it happens to be an appellate court where there is a judge who sits and hears the evidence. We're not at that stage. That would be in the U.S. tax court. The IRS Appeals Division is a branch of the IRS. And so as you can imagine, many tax professionals are very skeptical and cynical about the neutrality of the IRS appeals officer, since they are a branch of the IRS and they do get paid by the IRS. However, with the passage of the Tax Reform Act, going back now over a decade ago, the IRS did everything within their power to make this division as neutral as possible, so that there would not in any way be the specter or the impression to the public that the IRS appeals officer was merely an extension of the examination division. And so that the appeals division came about as a result of the passage of the IRS's new act, which went in effect back in 1998. So let's go back now to what we were talking about earlier. A taxpayer who disagrees with the revenue agent's findings may request this conference with the IRS Appeals Division, but he or she must do so within 30 days. It's for this reason that the cover letter on this revenue agent report is known as a 30-day letter. A taxpayer who receives a 30-day letter faces a strategic decision between A, requesting a conference with the IRS Appeals Division, or B, doing nothing. Now we're moving to step 3. If the taxpayer requests an appeals conference, but the parties don't come to an agreement, or if the taxpayer simply ignores the 30-day letter, there are repercussions. In these two scenarios that I've described, what I want to do is first tackle the scenario where the taxpayer simply ignores the letter and does nothing. There are consequences for doing nothing and for simply sitting on your hands and perhaps sulking about the whole situation. And that doing nothing is basically means that the IRS will send the taxpayer what's called a notice of deficiency. Okay, so by doing nothing, that doesn't in any way mean that the IRS is going to forget about the taxpayer. It means that the IRS is going to send the taxpayer a notice of deficiency, which is also referred to as a 90-day letter. And I'm also going to address a situation where the taxpayer requests an appeals conference, but the parties don't come to an agreement. If the parties do not come to an agreement before the IRS appeals officer, then similarly, the IRS will send the taxpayer a notice of deficiency. Now, the notice of deficiency provides a taxpayer with two options. The first is to pay the asserted deficiency and follow the refund procedures, or the second is to petition the tax court to contest the tax deficiency, the claim deficiency, within 90 days of the date the notice was mailed. That's very important. When it comes to the IRS and it comes to deadlines, if you blow a deadline, then you lose any right that you otherwise may have had to contest the claim deficiency. So it's very important that these deadlines are adhered to. And I have to tell you, I know many tax professionals that as soon as they receive notices, because they typically have power of attorney, which allows them to receive all notices relating to their client from the IRS. As soon as they receive a notice, they immediately go right to their calendar and they put a note in the calendar about the deadline for whatever forms have to be completed and submitted. Because if you blow a deadline, not only do you hurt your client, but you potentially become liable to your client for negligence in having missed that deadline. So it's very important that you be diligent about these deadlines. So again, going back to the notice of deficiency, it provides the taxpayer with two options. The first is to pay the asserted deficiency and follow the refund procedures. In other words, just get this over with and not contest it. Or B, petition the tax court to contest the claim deficiency. And if the taxpayer so chooses, they have within 90 days of the date the notice of deficiency was mailed to file a tax court petition. If they wait until even the 91st day, then they lose the right to petition the tax court to contest the underlying deficiency. The mailing of the notice of deficiency begins a period during which the IRS is prohibited from assessing tax. So that is one of the benefits that inures to the taxpayer, that that during that 90-day period, the IRS may not assess the tax. Assessment of the tax is basically concludes the matter, and basically means that the taxpayer has lost whatever right he otherwise may have had to challenge the underlying deficiency. So an assessment is kind of the end game, so to speak, in this whole process. And that's why the IRS is prohibited from assessing tax during this 90-day period, because at the end of the day, the taxpayer may in fact decide to petition the tax court. And so that is built in to allow the taxpayer that option without being threatened with an assessment during the 90-day period. Step 4, we're going to assume here that the taxpayer petitions the tax court. Assuming the taxpayer timely files his tax court petition, he can challenge the deficiency claimed by the IRS and any overpayment claimed by the taxpayer. Once again, during this 90-day period, the IRS is prohibited from assessing tax until the tax court judge makes a final decision. Who represents the IRS in tax court? Well, that's an interesting question, because contrary to popular belief, the IRS is not represented by the revenue agent in tax court, meaning the revenue agent that came to the determination that there was a deficiency. Instead, the IRS is represented by an attorney from IRS Chief Counsel's office. And this leads to a very interesting issue. The fact that the IRS is represented by an attorney from IRS Chief Counsel's office means that it's a good idea for the taxpayer, if they are going to tax court to challenge this deficiency, to have a tax attorney on their side. And the reason being is because the attorneys from IRS Chief Counsel's office are well versed in litigation, and they have a very strong background in tax. So they're combining two very specific areas of training that they've gone to school for, and that they've honed for potentially a long period of time. Now, under the rules of tax court, a CPA or an accountant, an enrolled agent, can take an exam and be certified under that exam to appear on behalf of the taxpayer in tax court. Now, not taking anything away from an accountant or an enrolled agent, it still is important to recognize that the adversary, the person on the other side of the table, is an attorney from IRS Chief Counsel's office who has a strong background in tax. And I can't emphasize it enough that it's very important that the person who is representing the taxpayer be on equal footing and have the same background as far as litigation goes and accounting. And for that reason, it's often recommended that a tax attorney represents the taxpayer in any litigation before the tax court. Certainly, the accountant can be called potentially as a witness during the trial, but to be on equal footing with your adversary, who is an attorney from Chief Counsel's office and has a strong background in tax law, it is imperative that the representative of the taxpayer be a lawyer who is seasoned as a litigator and understands these tax issues on a very nuanced level. So as a general rule of thumb, attorneys from chief counsel's office are more likely to make some concessions to reach an out-of-court settlement than the revenue agents are. And there's a variety of issues or a variety of reasons for that. Some are a little bit, some are more obvious than others. For example, when it comes to the chief counsel's office and the attorney representing the IRS, they tend to be less emotionally invested in the case than the original auditor. The auditor who did the examination very likely spent hours and hours doing the exam and can get very invested emotionally in it that they kind of put blinders on and dig their heels in the sand and refuse to see the other side of the argument. Once again, attorneys from IRS Chief Counsel's Office are less emotionally invested. They haven't spent nearly as much time as the examiner did on the case. And second, their dockets are extremely full. The attorneys from Chief Counsel's Office are not unlike county prosecutors who walk into court on a Monday morning with maybe a stack of 55, 60 cases. And they're looking at all of these cases and recognizing that it will be near impossible to try every single one of them. And obviously they've been given their marching orders and, and told not to give away the courthouse. So, if you were to have a very frank discussion with them, they would probably be quick to tell you that, if they have to try every single one of the cases, they will, and that that they may not, be willing to make concessions. But underneath the surface lies the human element and the fact that they don't want to have to try any more cases than the judge does in his courtroom. And so they might be willing to make some more concessions or to reach an out-of-court settlement and bend a little bit, unlike the auditor who dug his or her feet into the sand and drew a fine line, in opposition to any settlement and refused to give any concessions. The third reason that these individuals are more likely to make some concessions is that they're quite familiar with the hazards and costs of litigation, and they'll take those into consideration when it comes to their negotiations. So what this boils down to is that attorneys from IRS Chief Counsel's Office are no strangers to the courtroom. They may know the judge well. They may have had a number of cases before the judge. They are well versed in the case law, and they may know right away, whether they've got a losing issue on hand, or whether the issue could come down to a coin toss if there isn't well-established case law. And for those reasons, they might weigh out the hazards and costs of litigation and decide that it might be within reason, and it might be appropriate to make some concessions that the examiner or auditor wasn't willing to make. However, there may be no agreed resolution, and if so, the matter will proceed to a bench trial. Now, only a very small number of these cases make it to a bench trial because it's essentially the bottom of a funnel. If the taxpayer loses, he can appeal the resulting decision to the Court of Appeals for the circuit in which he resided at the time he filed the petition. So, as a general rule of thumb, let's say, for example, that the taxpayer filed the petition in New Jersey. New Jersey is in the Third Circuit Court of Appeals. The Third Circuit Court of Appeals encompasses New Jersey, Pennsylvania, and parts of Pennsylvania and New Jersey. And so if that was where the taxpayer lived, say New Jersey, at the time he filed the petition with the tax court, then the Third Circuit Court of Appeals would be the court that the taxpayer appeals to if he loses in U.S. tax court. So very simply, if the tax court judge rules against the taxpayer and in favor of the IRS, the taxpayer would appeal, if he so chooses, the judge's decision to the Third Circuit Court of Appeals. Step 5. If the taxpayer does not respond to the notice of deficiency by petitioning the tax court within those 90 days or by paying the tax outright, the IRS will make an assessment. And once again, an assessment is pretty much the end of the road. The only thing left after an assessment is basically for the IRS to begin collections actions by way of levies, garnishments, perhaps even a lien. So an assessment is is basically the end of the funnel and basically forecloses the taxpayer from any opportunity to attack or dispute the underlying deficiency. It's the end. And so for that reason, I always tell taxpayers that assessment is essentially the end of the road, and basically once the assessment is made, it becomes a debt of the taxpayer. Now, the IRS must give notice and demand for payment to the taxpayer as soon as practical and within 60 days of making an assessment. So because this assessment is the end of the funnel and theoretically the last stage, the IRS has certain requirements that it must follow. And one of the most strict requirements that it has to follow is the notice requirement. It has to, the IRS, that is, must give notice and demand for payment to the taxpayer as soon as practical and within 60 days of making that assessment. If the taxpayer refuses or neglects to pay the tax after notice and demand for payment is made, well, that's when collection actions could commence. The amount of the tax liability would become a lien on, or could become a lien on, all the taxpayer's real and personal property until it is paid. So the taxpayer who decides to be, let us say, recalcitrant and basically puts up a wall, refusing or neglecting to pay the tax after having received notice and demand for payment, risks having their tax liability become a lien on their real and personal property until it is paid. So it's as upset as the taxpayer might be, and as hostile as the taxpayer may become in the wake of the assessment and having received the notice and demand, the last thing that you should counsel your client to do is to dig his head into the sand and simply refuse to address it and refuse to discuss the possibility of a payment plan, because if the taxpayer does that, then they risk the possibility of the liability becoming a lien on all of their real and personal property. And again, I realize that it's very emotional, and a lot of times the taxpayers just become so enraged over this that they decide to ignore it. But ignoring it isn't going to help the problem. It's only going to make it worse. Now, I'd like to take a slight digression right now into eggshell audits. What is an eggshell audit? Well, here's the best way that we can back our way into this. The IRS often audits taxpayers who, unbeknownst to them at the start of the exam, have major criminal problems. The practitioner, whether that be the accountant or the attorney assisting taxpayers in this situation, will likely have done their homework and ascertain that there's a problem. And if they've done their due diligence and learned that there's a problem, they probably will also know what the scope of that problem is. The strategy thus becomes one of damage control. Now, a traditional source of referrals to the CI division of the IRS, CI is short for Criminal Investigation Division, is the civil audit. And that's why we're going to focus on this for a little while. So once again, an eggshell audit is an audit where the taxpayer and or his advisor knows that there are potential criminal implications that could arise during the audit of one or more of the tax years that the examiner is auditing. And here is the very unsettling part of it. While the taxpayer and his advisor know about this, they have no way of knowing whether it will be uncovered by the examiner unless it happens to be so egregious that that it would be impossible to be missed. So this is what the conundrum is, because in some cases the practitioner may feel as though it is minor and trivial, and that it may not get picked up by the examiner. In other cases, on the other end of the spectrum, it is so prominent and so obvious that it would be impossible to miss. Now, in between those two extremes on this spectrum is the gray area, and that's where most of these cases lie, where it could be picked up by the examiner during the audit, but maybe not. So we do have some rules of thumb in how to treat these eggshell audits. And as a general rule of thumb, it's important to recognize that the IRS is mainly concerned with the underreporting of gross income. That is what they focus on very specifically, the underreporting of income. That's not to say that the overreporting of deductions won't result in the referral of a case to the Criminal Investigation Division. It simply means that the underreporting of gross income is kind of at the top of the list of infractions that automatically result in a referral to CI. Now, if we get into the weeds a little bit deeper, we can talk about amounts as well that could trigger the revenue agent to make a referral to CI. And I do have some statistics from a couple of years ago, unfortunately they're not too recent, which suggest that there is a certain amount of gross income that is underreported that would in fact result in the examiner referring the matter to what's called a fraud technical advisor. And so the fraud technical advisor is essentially a supervisor of the examiner who will review the file and if there is the potential for fraud before the case gets forwarded to the criminal investigation arm of the IRS. So the fraud technical advisor is kind of the liaison, if you will, in making the determination as to whether this case has significant badges of fraud to warrant a referral to CI. Because as you can imagine, CI receives a number of these referrals, and they are not, they don't have unlimited resources. And so they would prefer to sink their teeth into bigger cases, ones that are easy to prove and that will have a strong deterrent effect on the taxpayer population than the small cases. And so for that reason, typically the amount of underreporting of gross income has to be of an amount and of a size that it warrants referral to CI. Otherwise, CI is going to kick it back and say, come up with some resolution with the taxpayer. We don't want to waste our time on this, our limited resources, and we don't want to risk the backlash that might come about as a result of prosecuting an individual who underreported gross income in a small amount. And by small amount, maybe it's $20,000, $30,000. These are not those cases are, at the end of the day, the small minnow cases, and they don't really have the same shock effect and deterrent effect that the bigger cases have. And they also paint the IRS in a negative light because at the end of the day, the public might feel as if the IRS is, is spending, scarce resources on going after, small fish in the pond as opposed to big fish. And so they don't want to risk that public, risk that public relations nightmare. So with eggshell audits, it's too late for a voluntary disclosure. A voluntary disclosure is basically where the taxpayer recognizes that he or she made a mistake and that it was willful, meaning intentional and knowing, and wants to get right with the IRS. And so they have a right, the taxpayer that is, to make what's called a voluntary disclosure to basically disclose the error that was made or the errors that were made, and to kind of do a mea culpa for it, assuming that the taxpayer files a voluntary disclosure before the audit commences and before the IRS has called them out on it. Then this is a way for the taxpayer to come into compliance without the risk of criminal prosecution. And so it's basically a safe harbor for the taxpayer. But as I like to say, if the taxpayer is already on the IRS's radar screen and has already received a notice of an upcoming audit, or has already been contacted by the IRS with questions relating to the specific issues that relate to fraud, then it's too late at that point. So essentially, if the fox is has already caught the scent of or if the greyhound has already caught the scent of the fox, then it's too late. So voluntary disclosure is specifically meant for those cases where the IRS has yet to detect the taxpayer's malfeasance or fraud, and the taxpayer is kind of coming forward to claim responsibility for it. But in the case of an eggshell audit, it's too late for a voluntary disclosure. In some cases, disclosure to the agent about the fraud may be the best option. I realize that you might have to do a double take there, but that is the case in some cases where disclosure to the agent may be the best option. For example, when the practitioner can obtain a reasonable level of assurance that the civil agent will not refer the matter to CI, so that disclosure of the fraud to the agent will not result in a referral for criminal investigation, that might be the type of case where the practitioner might just want to come clean with the examiner and let him or her know that there were some errors on the return that resulted perhaps in an underreporting of gross income or an overreporting of deductions. And so it's very important for the practitioner to really give this some thought, because as you can imagine, this could be lethal if the practitioner, God forbid, announces that to the examiner that there was fraud, and then the examiner refers the case to the fraud technical advisor, who then in turn refers the case to CI. That would be absolutely devastating. So the practitioner has to obtain a reasonable level of assurance from the civil examiner that the case won't be referred to CI before disclosing this fraud. Disclosure to the agent may still be the best option, even if reasonable assurances cannot be obtained. If the fraudulent item, for example, is so obvious that it is not a matter of if, but when the agent will uncover it, the best strategy may be to disclose the error in the hope that by correcting the item, the disclosure will gut the willfulness element to the extent that CI may not be interested in taking the case. So here's what I mean by that. In order to prove the crime of tax evasion, the mental element that the government has to prove beyond a reasonable doubt is willfulness. Just like in street crimes where where the crime has to be committed intentionally, in tax crimes there has to be a knowing and intentional aspect in order for the taxpayer to be found guilty. Willfulness has been watered down substantially in the last couple of years, but thanks to many judges and circuit courts, it's still in many circuits held to a very heightened standard. And by that I mean that the government has to establish that there was a knowing and intentional violation of a known legal duty, and that is a heightened requirement. To the extent that the practitioner discloses to the examiner during the audit that there was an error, that tends to blunt the willfulness element at trial. Because if we were to play out this scenario at a trial where the government is arguing that the taxpayer intentionally and knowingly violated a known legal duty by underreporting his gross income, the defense attorney can then stand up in closing and argue, wait a second, ladies and gentlemen, the government wants you to believe that Mr. Smith was intentionally trying to hide his income from 2014. But I want you to remember what you heard in testimony during this trial, that when this audit began, Mr. Smith, through his accountant, came forward to tell the IRS revenue agent before the agent discovered it that there was an underreporting of gross income. He wanted to come clean, and he wanted the revenue agent to know that he made a mistake and that he underreported his gross income. How could that be viewed as intentional and willful if he came forward to voluntarily announced that he had underreported his gross income. So you see what I'm driving at right now. The defense attorney has some arguments to make by way of referring to the disclosure, the voluntary disclosure of the taxpayer to the examiner at the time of the eggshell audit that there was an underreporting of gross income. You know, he came clean. He's not perfect, but he wanted to get right, make it right with the IRS. And before the revenue agent could discover the error, the taxpayer himself came forward to let the examiner know, and to let the examiner know that he or she was prepared to pay whatever deficiency resulted from that underreporting of income. So it does give the defense attorney some fodder to argue that there could not have been any willfulness since the taxpayer had voluntarily come forward to disclose it. Assuming the civil exam proceeds without making a full disclosure, it's very important for the accountant or for the attorney representing the taxpayer to limit the contact between the agent and the taxpayer. What we like to call this here is auditing the agent. And this is incumbent upon the practitioner who's representing the taxpayer. What I mean by auditing the agent is that the practitioner should track the investigation to keep current on what the agent knows. And for reasons that we've just discussed, the practitioner needs to have his finger on the pulse, or her finger on the pulse, so that they know whether the examiner has already caught wind of this error, or if it just kind of slipped through the back door. IRS civil agents have an obligation to notify the taxpayer before contacting third parties, and to keep a record of the third parties contacted during the civil phase of an investigation. So that certainly helps the practitioner to know or to audit the agent, and to keep their ear to the ground to see what the revenue agent knows. But I need to preface what I just said about the IRS examiner having an obligation to notify the taxpayer before contacting third parties. Though that applies to a situation where a subpoena has been issued to a third party. Now, there are certainly cases where the IRS examiner will pick up the phone and simply call the third party up and try to be civil about it and request certain information from the third party. If the third party is willing to turn over information to the examiner without the need for a subpoena, then the IRS civil agent has no obligation to notify the taxpayer about the contact or the request that the examiner has made from the third party. It's only in those cases where a subpoena has been issued to the third party that the IRS examiner has an obligation to notice the taxpayer. So, as a general rule of thumb, if you are representing the taxpayer, you want to, when you meet with the taxpayer in the wake of this audit, find out from the taxpayer about third parties that he or she has had contact with, perhaps vendors, perhaps employees. It could be any one of a number of different people, depending on the type of audit that we're dealing with, and make a list of those people. And it's not a bad idea for the practitioner to reach out for these individuals, assuming that the taxpayer has a good relationship with them, and basically talk to these individuals and say, hey, If you're contacted by the IRS and you wouldn't mind letting us know, we'd greatly appreciate it. And here, all we're doing is trying to establish a good rapport with these third parties in the event that the examiner reaches out for them and requests information from them without hitting them or serving them with a subpoena. This is not strong arming a third party or trying to intimidate a third party. This is not at all what I'm suggesting here. It's merely reaching out for these third parties, introducing yourself to them, perhaps even letting them know that the taxpayer is being audited, and to just simply, ask them if they wouldn't mind contacting you in the event that they receive a call from an IRS revenue agent regarding an audit of John Doe. Okay, and that way it helps you as a practitioner keep your finger on the pulse of things, so that you are auditing the agent and you are learning as this unfolds, what direction the examiner is going in and what information they're gathering, and that will help you to learn, whether the examiner has begun to focus on a potential issue that is related to fraud. So Section 7609 requires the IRS to notify the taxpayer of summonses issued to third parties. I misspoke before. I said subpoenas, but I was referring to summonses. The notice requirement, however, is void in criminal investigations. Don't forget that the way for the IRS to circumvent this whole notice to the taxpayer is by not issuing a third party a summons and simply doing it in a cordial way. If a witness voluntarily provides info without the need for a third party summons, the record may be collecting dust in the agent's file, generally until it's requested by the defense. However, as we discussed before, establishing a good relationship with the potential witnesses during a civil exam and asking these witnesses to call you if the IRS contacts them will put you in the know a lot sooner than receipt of records via a FOIA request. A FOIA request is basically where you submit a request for all of the information in the agent's file that is public record, and that may in fact be collecting dust in the agent's file. That's also a way to ascertain what information the examiner has at their fingertips, this FOIA request. They sometimes take a long time, and usually it's like a data dump of information that comes out of it. But nonetheless, if all else fails, a FOIA request may generally be just what the doctor ordered, especially if there are a number of third parties and it was impossible to have contacted all of them, or if there was skepticism on whether the third parties would in fact notify you as a practitioner if they did receive a call from the IRS examiner. I'm going to stop here and just take a short little break. Now, if the revenue agent issued a third-party summons and neither you nor the third party, or I'm sorry, the taxpayer rather, received notice, that summons probably was issued incident to a criminal investigation, issued with notice sent to the incorrect address, or issued in violation of the notice requirement. Of course, it would be best for the taxpayer if it was issued in violation of the notice requirement. But before automatically going to that conclusion, it's very important to rule out the other two, namely A, that whether it was issued incident to a criminal investigation, and B, whether the notice was sent to the incorrect address. So before automatically assuming that it was issued in violation of the notice requirement, be sure to rule out the other two. Now, what happens if the civil audit turns quiet? That can be a little unsettling and a little ominous. It could mean a number of different things. It could mean that that a referral to CI has taken place. It could mean that the fraud technical advisor was referred the case by the examiner and is in the process of deciding whether the case has sufficient badges of fraud in order to forward it to CI. It could mean something very ominous, or it could simply mean that the revenue agent is swamped and has so many other things going on, or is in training, or perhaps is on vacation. So what do you do in cases like that? Before panicking and assuming that things have taken a bad turn, you should contact the agent or a supervisor immediately to find out what's going on without tipping the agent off about anything nefarious. It's also not a bad idea for a FOIA request to be considered if it becomes clear that the case will be referred to CI. After the agent has completed the audit, it can take one of two directions. First, the agent may not believe there to be any fraud and may close the civil exam without any adjustments in what is referred to as a no change letter. Obviously, that would be a home run, especially if the practitioner and the taxpayer were holding their breath because of the possibility of fraud. But even when there is no fraud, and it's just a straight audit, this is the holy grail, so to speak, where the examiner comes back with no proposed adjustments and issues a no change letter. Second, the agent may determine that the case has sufficient criminal potential to be referred to CI. Although the Internal Revenue Manual requires that the agent refer the case to CI whenever there is a firm indication of fraud, in practice, agents are taught to consult with their group managers, or as we discussed before, their fraud technical advisors, to review the fraud potential in an exam. While the referral can occur any time during the examination, if it's going to happen, it normally happens near the end. Keep in mind that the examiner wants to have as much ammunition as possible to sustain their belief of fraud. And the more information that they compile, perhaps the stronger the case for fraud becomes. That's why these referrals generally happen during the end of an examination and not during the beginning or middle. So what type of cases are generally referred for prosecution? Well, let's back up a little bit and shed some light on the criminal tax enforcement system. And first, what I should do is just give you a procedural overview of how this works. We've talked about the revenue agent finding some badges of fraud. And by badges of fraud, all we're referring to here is the underreporting of gross income, where it could be any one of a number of things. It could be the concealing of assets. It could be the failure to disclose bank accounts. It could be the parking of money offshore in secret bank accounts, in the Cayman Islands. It could be the use of a corporation or an independent entity that is used to disguise the ownership so that the IRS cannot trace the funds back to the taxpayer. There's so many potential badges of fraud out there, but in the event that the revenue agent identifies sufficient badges of fraud that would warrant a further look into the matter, he or she would refer it to their fraud technical advisor. The fraud technical advisor would review it, and if the fraud technical advisor believes that there are grounds for a referral to CI, they would then forward the file to CI. Now, CI then filters the cases, and if they determined that there is sufficient fraud potential, they would refer the case to the U.S. Attorney's Office. And in Washington, D.C., there is a branch of the U.S. Attorney that specializes in criminal tax matters. And they are, as I said, based in Washington. They filter the cases that they receive from CI, and in some cases they decide not to pursue them. In other cases, they decide to pursue them, but they send them to the local branches, the local U.S. Attorney's offices for prosecution. So if the matter, in their opinion, is should be prosecuted, but it's of a nature that it is perhaps a collateral issue to a money laundering case or to some other type of crime, and it's not as monumental, as anticipated, they might kick it to one of the local U.S. Attorney's offices. In New Jersey, for example, we have a U.S. Attorney's office in Newark, and they are, the U.S. Attorney's Office tax division in Washington has the right to delegate these cases to the various local U.S. Attorney's offices. In the case where the matter is egregious, and and the tax evasion is of a magnitude that that the attorneys from the U.S. Attorney's Office in Washington, specializing in tax, want to handle, then they will handle the matter directly. But they have the absolute discretion to delegate cases to the local U.S. Attorney's offices with instructions that those cases be prosecuted. Now, believe it or not, there's some dissension that happens between the assistant U.S. attorneys in these local branch offices and the U.S. attorneys in the tax division in Washington, because as you can imagine, if you are an assistant U.S. attorney who has a caseload that is quite large and has just been assigned a case for tax prosecution, it's not necessarily the most sexy case to handle, and it requires an inordinate amount of research to get up to speed on what the issues are if the assistant U.S. attorney in the local branch doesn't have any background in tax. And so there's sometimes some tension that exists between the local assistant U.S. attorneys and the U.S. attorneys in the Washington tax office that decide to delegate the smaller cases, if you will, to the local branches. So where we are right now when it comes to prosecution is we are pretty much in the Department of Justice tax division right now. Excuse me. And what we need to recognize is that the Department of Justice tax in Washington has limited resources. So if CI has limited resources, DOJ tax has even less limited resources. So it's essential for them to coordinate and prioritize what cases they are going to single out and focus on for prosecution. In other words, what cases are going to result in the maximum bang for the enforcement buck. DOJ tax handles all tax trials in the federal courts of the United States. It has authority to approve all tax-related indictments. Now, again, I mentioned before that that in no way, shape, or form prevents DOJ tax from delegating their smaller cases, smaller tax prosecution cases to the local assistant U.S. attorney offices. And if, for example, we're referring to New Jersey, that would be the Newark office. DOJ's criminal enforcement section applies its investigative and prosecutorial resources strategically so as to support the overarching goal of our tax system. And what is that? Well, this comes right out of the playbook. It's to preserve the integrity of the United States' self-assessment tax system through vigorous enforcement of the Internal Revenue laws. How does it do this? Well, it does this by prosecuting relatively few cases each year. And by few, I do mean few. The latest statistic that I was able to find found that anywhere from between 2,000 to 3,000 cases were actually prosecuted. Now, I don't mean trials. I mean prosecuted. A lot of these cases end up in pleas. But if you consider the fact that tax evasion is a very pervasive form of activity, and that only between 2,000 and 3,000 cases were actually prosecuted, even though the statistic is a little bit old, you'll see that a lot of cases were not prosecuted and were kicked back perhaps to CI and perhaps to the field division to be resolved at that level. So it's important to recognize that DOJ has limited resources and that they are looking to achieve the maximum bang for the enforcement buck, meaning that they are trying to maximize the deterrent effect with their limited resources. So who does that mean that they focus on? They focus on, on those people that have achieved notoriety in the public. They are not necessarily, they're not necessarily our pop stars. However, those do attract a lot of attention, and so they do tend to focus on movie stars and those that have a very strong following in the media, and that will certainly get the attention of the public. They also focus on professionals, attorneys, businessmen, hedge fund managers, accountants, CPAs. Those individuals are very likely to catch the attention of the tax-paying public and they are very likely to be made a strong example out of. So those are the individuals that definitely fall on the IRS's radar. So if we were to summarize this, the U.S. Department of Justice tax focuses on the strongest cases in which conviction is highly likely and zeroes in on those targets with the high profile. As we've discussed, the celebrities. I think the latest celebrity to be charged and I believe even convicted of tax evasion was an individual from the show Jersey Shore. I think it was Mike the Situation. He was prosecuted for a number of tax crimes as well as non-tax crimes. And he was just the type of person that the IRS looks for to make an example out of. And they do this so that the conviction will receive the maximum amount of publicity, encourage compliance, and heighten the deterrent effect among would-be tax cheats. And all of that is lawful. None of that, while it might appear to be malicious and mean-spirited, to pick on, a celebrity or a professional from one of our esteemed professions, all of that is par for the course. There's nothing against the IRS singling out certain individuals over others to prosecute, as long as it squares with the overarching goal of the tax system. DOJ and the IRS accept the fact that there is a substantiality requirement to tax evasion. What that means is that the IRS will recommend criminal prosecution under the Section 7201, which is the tax evasion statute, only if the average yearly additional tax for criminal purposes is at least $2,500 in specific items cases with uncomplicated facts, or at least $10,000 for the prosecution period in indirect method cases or cases with complicated facts. Now, I preface this statistic with this footnote. These numbers that I'm citing for you are believe it or not, 10 years old. So in order to adjust for inflation, I would say you'd have to add a substantial amount onto these figures. But I just wanted to give you a general idea that there are some guidelines that and triggers, so to speak, that and thresholds, I should say, that the IRS will look at before making a referral, and that the U.S. Department of Justice tax will zero in on before making the decision to prosecute a case. And back when these statistics were gathered, it was at least $2,500 in specific items cases with uncomplicated facts, or $10,000 for the prosecution period in indirect method cases or cases with complicated facts. Again, it's important to adjust for inflation because these figures are old, but the whole point here is that there are thresholds that the IRS will look at before unilaterally deciding to prosecute a case. Upon receipt of the referral from CI, CES determines whether the case is within its prosecution enforcement priorities. So here we're talking a little bit of procedure. CI receives a referral from the field office, specifically the fraud technical advisor, and they will determine whether the case fits within their prosecution enforcement priorities. They have, the CI, the discretion to decline the IRS's recommendation and return the case to the IRS either for further investigation or with instructions to close out the criminal investigation. However, if CES approves the case, it will usually forward it to the U.S. Attorney's Office for the district where venue for criminal prosecution lies. So this gets back to what we discussed earlier, that that they have the absolute right to delegate cases to the local U.S. attorney's offices. And that is a source of an incredible amount of friction and tension because these assistant U.S. attorneys carry very large caseloads, and tax cases don't have the same sex appeal that a bank robbery of a Chase bank has. And so they're not very sexy cases to try and to bring to trial, and yet they can be some of the hardest cases to prove, which by default means that a lot of them do have to be tried. So you can imagine a U.S. attorney with an extraordinary caseload being assigned a tax case who knows nothing about tax and who's now obligated to take this case to completion, having to try it. And you can see that that immediately results in some tension between the assistant U.S. attorney and the Department of Justice Tax in Washington that delegated the case to them with instructions to assign it and to prosecute it to completion. Privilege. Section 7525A1 of the Internal Revenue Code. This covers the common law protections of confidentiality that apply to communications between a taxpayer and a federally authorized tax practitioner. I just want to scratch the surface of this a little bit because privilege is a very important issue in the world of tax, especially when we get into examinations. There's a case known as U.S. versus Arthur Young and Company. In that case, the Supreme Court of the United States held that accountants' work papers are not protected from an IRS summons under the work product doctrine. All right, so I want to repeat that in order to emphasize it. The Supreme Court held that accountants' work papers, that's basically their notes, and that they gather during the course of preparing returns. These work papers are not protected from an IRS summons under the work product doctrine, which means that the IRS can issue an accountant a summons for their work papers, and the privilege that was established between the accountant and his or her client, the taxpayer, is not strong enough to prevent the accountant from having to surrender the work papers to the IRS. Now, information and documents that are already in the possession of a tax preparer are not privileged either and could be obtained by the IRS. And so, as you can imagine, this is a pretty scary scenario because these work papers could reveal a treasure trove of information that the IRS could use to prosecute the taxpayer or to build a case against them. It could contain even badges of fraud, and yet these are fully disclosable and must be turned over by the accountant that receives a summons from the IRS. Now let's talk about the attorney-client privilege in the tax realm. The attorney-client privilege, on the other hand, is stronger than the accountant-taxpayer privilege. The attorney-client privilege protects legal advice and tax advice. However, where the advice is tax advice, the scope of the privilege is limited. So you can look at it from the perspective that the courts giveth and then they taketh. So while the attorney-client privilege is a little bit stronger than the accountant-client privilege in the tax realm, At the same time, the scope of the privilege is limited when the attorney is giving tax advice to his client. So what this translates into is that first, there is no privilege for communications relating to investment or business advice or services. So to the extent that the tax attorney is giving his client advice on the when it comes to communications relating to investment or business, there is no privilege. Second, the preparation of tax returns is generally not considered to be legal advice within the scope of the privilege. So if the taxpayer's attorney is an accountant as well as an attorney, or possesses knowledge of tax return preparation, and the taxpayer has hired the tax attorney to not only provide him with advice or services for tax preparation, but actually asks him or her to prepare his returns, the preparation of the returns by the attorney is generally not considered to be legal advice within the scope of the privilege. And to the extent that the attorney receives a summons to turn over information that is related to the preparation of tax returns, he or she would be obligated to do so. So very important to understand this, that accounting functions undertaken by lawyers who possess knowledge of accounting is not covered by the attorney-client privilege in the tax realm. And so while the privilege tends to be a little bit stronger than the accountant-client privilege, in the sense that the attorney-client privilege protects legal advice and tax advice, when it comes to tax-related advice and preparation, the courts have held that information must be turned over and is discoverable by the IRS upon the accountant and upon the attorney receiving a summons. So a quick and dirty rule here is that any legal advice given by the attorney that ultimately ends up on the client's tax return is treated as given as part of return preparation and is not covered by the privilege. I'm going to repeat that again because that is huge. Any legal advice given by the tax attorney that ultimately ends up on the client's tax return is treated by the courts as given as part of return preparation and is not covered by the privilege. So what that means is that legal advice that was given by the tax attorney that resulted in the client taking a certain position on his return is fully discoverable by the government. And all the government needs to do is issue the attorney a summons demanding that information. Of course, the attorney, through his client, has the right to oppose the summons, and there would then be a subsequent hearing to determine whether the information is discoverable and must be turned over. But the case law states specifically that if it was legal advice that the tax attorney gave his or her client that resulted in the client taking a certain position on his or her return, then that legal advice must be surrendered by the attorney upon receipt of the summons. So, for example, we have a case here known as U.S. versus KPMG. In that case, the court held that a tax opinion regarding the tax consequences of certain investment portfolio transactions was not subject to the attorney-client privilege because the opinion was prepared in conjunction with preparation of a tax return. And so, as you can see here, while the attorney-client privilege is stronger than the accountant-client privilege, any legal advice, in this case it was a tax opinion regarding the tax consequences of these investment portfolio transactions that the taxpayer engaged in. The court held that they were not subject to the attorney-client privilege and had to be turned over to the government because the opinion given by the attorney was prepared in conjunction with preparation of the tax return. Now, we do fortunately have a case that is a little more taxpayer friendly. It's known as the case of U.S. versus Frederick. It comes from the Seventh Circuit Court of Appeals, and thankfully it takes a more nuanced approach to the attorney-client privilege. In that case, the Court of Appeals said that, quote, "It cannot be assumed that everything transmitted to the tax attorney by the taxpayer was intended to assist him in his tax preparation of a tax return and thus might be conveyed to the IRS." So that's the whole theory behind why the attorney-client privilege does not protect opinions and advice that is given by the tax attorney to the taxpayer that ultimately results in the taxpayer taking a certain position on his return. The reason why it's not privileged is because it's the position that the taxpayer takes as a result of that opinion given by his attorney is conveyed to the IRS through the return. The return itself is the proof of the taxpayer having taken that advice and taken that position. The return reflects that. And so because that return screams out to the IRS that that the taxpayer received this advice from his attorney, and as a result, took this position on his return, how could it possibly be considered privilege? Because it's already been made public by way of having been filed with the IRS and has already been made public to the world, so to speak, as a result of the filing of the return itself. And so that's the theory behind why the courts don't protect the advice, the tax advice given by the tax attorney to his or her client. But in U.S. versus Frederick, the Court of Appeals for the Seventh Circuit took a more nuanced approach and said, hey, we cannot assume in every situation that everything transmitted to the tax attorney by the taxpayer was intended to assist him in preparation of his return and that it might be conveyed to the IRS. So there's flawed logic here. Just because the taxpayer, just because the taxpayer, transmitted this information to his attorney to assist him in, transmitted this information to the tax attorney doesn't mean that it was intended to assist the taxpayer in the preparation of his tax return. So I realize that we're going around in circles here, but thankfully, U.S. versus Frederick was able to see right through this and basically put a hole in this reasoning that everything that the taxpayer transmits to the attorney was intended to assist him in preparation of his return and would be conveyed to the IRS. So thankfully, the Seventh Circuit took a more nuanced approach and dispelled that myth. And similarly, in that case, the court recognized that information furnished to a tax attorney could just as easily have been offered by the client for the purpose of receiving legal advice. And legal advice here is what triggers the heightened privilege of the attorney-client privilege. So once we get into the realm of legal advice, we're no longer dealing with tax advice for what position to take on a return. We're dealing with a higher privilege, and that involving legal advice, and that is what is enshrined with a lot more protection when it comes to the attorney-client privilege than merely tax advice. Kovel accountants. What is a Kovel accountant? You might have heard that term used before. A Kovel accountant is an accountant that is brought under the cloak of the attorney-client privilege, which, as we've already discussed, is a stronger privilege than the tax practitioner client privilege. The Kovel accountant should be engaged as early in the process as possible in order to derive the maximum benefit from the accountant's work. And we'll discuss yet another reason for why it's important for the Kovel accountant to be engaged as early on in the process as possible. Now, one of the obstacles that the taxpayer puts up when it comes to the accountant recommending the use of a Kovel accountant is the insufficiency of the funds, or how this is going to blow the budget out of proportion. I can't afford it. So these are many of the obstacles that have to be overcome in order to convince the client to retain a Kovel accountant. But to the extent that you can convince your client that a Kovel accountant is in his or her best interest, and most importantly, that the budget permits this, because at the end of the day, if the client doesn't have the funds, then he doesn't have the funds. But if it's just a matter of the client balking over the fact that he or she is going to have to pay, another professional, X number of dollars more, then it's your job to sell this Kovel accountant to your client, because at the end of the day, it might be the one thing that separates your client, between his freedom and a cold, dank cell at a state prison. Or federal prison. So very important to have this heart-to-heart discussion with your client about the use of a Kovel accountant. So my recommendation is that, to the extent the budget permits, 3 professionals should be engaged during the eggshell audit. The first is a tax attorney, the second is a forensic accountant, and the third is an independent accountant. The Kovel accountant would assist the tax attorney in gathering all potentially relevant information, and the tax attorney would determine what portion of the information to disclose to the independent return preparer. So we have kind of 3 cogs here. We have the tax attorney, we have the forensic accountant, and then we have the independent accountant. And the way that these 3 work in unison is that the Kovel accountant is hired by the tax attorney to assist the tax attorney in gathering all potentially relevant information. The tax attorney then determines what portion of that information to disclose to the independent return preparer. In that way, while the independent preparer's knowledge is discoverable by the IRS, the information disclosed to the Kovel accountant would remain privileged under the attorney-client privilege. So by the attorney hiring the accountant, that brings the accountant under the umbrella of the attorney-client privilege, and essentially makes their work product, the accountant's work product, privilege to the extent that the attorney client privilege is established. So the same relationship or the same privilege that the attorney enjoys with the client is extended to the accountant that is hired by the attorney. And that accountant is referred to as a Kovel Accountant. Now, keeping the roles of the original preparer and the Kovel Accountant distinct best preserves the attorney-client privilege. Why is that? Well, if you were to use the original preparer as the Kovel Accountant, that would be a recipe for disaster. Even though it might save money, at the end of the day, it likely won't protect your client's liberty and freedom. And the reason is because the risk is too great that the original preparer will not be able to distinguish between what he or she learned prior to the time the prior to the time the privilege attached, and what he learned after the privilege attached. So remember that only the latter, meaning what was learned after the attorney-client privilege attached, is covered by the attorney-client privilege. What was learned by the accountant, in this case the original accountant, before the attorney-client privilege attached, is only privileged to the extent of the accountant-client privilege, which we've already discussed is a very watered-down privilege, and one that does not protect nearly as much as what is protected by the attorney-client privilege. So if the original preparer that has been doing the preparation work for the client is used during the eggshell audit, and again, it's a recipe for disaster, because how can you pinpoint in time the moment that the attorney hired the original accountant and thus brought him or her under the umbrella of the attorney-client privilege? How can you identify that moment in time and distinguish it from the moment in time when the accountant was merely working for the client and was merely operating under an accountant-client privilege? And this is vital because the argument can be made by the government that the attorney-client privilege didn't attach until way later than the attorney was actually retained, and thus information gathered by the accountant even after the attorney was hired should be fully disclosable because it was only covered by the accountant-client privilege, which is a much weaker privilege than the attorney-client privilege. Again, what we're trying to establish, the goal here is for the attorney to be hired, to immediately retain the services of an independent accountant that would be brought under the umbrella of the attorney-client privilege. The way that happens is by the attorney hiring the accountant, and I like to refer to this accountant as either a forensic accountant or a Kovel accountant. It's by the attorney hiring that accountant directly, and by doing so, that brings the accountant under the attorney-client privilege. And so the information that is privileged, the information that is disclosed by the taxpayer to the attorney is given the same weight, the information that's disclosed by the taxpayer to that Kovel accountant is given the same ironclad privilege as if the taxpayer was turning it over to the attorney himself. Let me repeat that again. By bringing the forensic accountant under the cloak of the attorney-client privilege, information that is disclosed by the taxpayer to the forensic accountant is given the same heightened privilege as if it was disclosed by the taxpayer to his or her attorney, because the accountant has been brought under the cloak of the attorney-client privilege. I realize that that's a mouthful, but that's why it's critical for the attorney to hire a forensic accountant, and for that accountant to be a Kovel accountant, because then we have heightened privilege and it becomes harder for the IRS to obtain information from the Kovel accountant because the privilege is so much stronger than the run-of-the-mill ordinary accountant-client privilege. Moreover, the initial preparer already possesses enough information, sadly, to provide a roadmap to the fraud. And this is why you don't want to reuse the original preparer. And even by bringing him or her under the cloak of the attorney-client privilege, that might not help the situation, because what happened before the original preparer was brought under the cloak of the attorney-client privilege, the information, rather, that the original preparer possesses before he or she was made into a Kovel accountant might be enough to provide a roadmap to the fraud. And that might make him witness number one in the government's case against the taxpayer defendant. And so for that reason alone, you don't want to take the original preparer and, in the name of saving, money, turn him into your Kovel accountant, because he is or she is already might possess enough information to sink the taxpayer ship and to cause him to be prosecuted and convicted of tax fraud. So again, it's best to start fresh with a new forensic accountant altogether and have the attorney hire him so that he or she is brought under the cloak of the attorney-client privilege. And so the privilege asserted is stronger, and it becomes that much harder for the government to obtain information from the Kovel accountant. So how do we craft an airtight Kovel agreement? First, the attorney should engage the Kovel accountant and not the client. It's also recommended that the lawyer pay or at least approve the accountant's invoices. Second, a new accountant, as we've discussed, rather than the client's existing accountant, should be engaged. The client will want his existing accountant to be used for a variety of reasons. I've heard anything from he's my best friend to his family's been coming over to my family's 4th of July celebration for the last 20 years to I don't want to have to spend more money or any more money than I have to, because I'm already going to have to pay the IRS a lot of money as a result of this audit. You have to overcome these barriers, specifically if there are concerns about the potential of fraud being discovered in this, quote, eggshell audit. Again, being penny wise and pound foolish could wreak havoc later on. For example, it might be difficult to distinguish between what the accountant knows outside the Kovel agreement and what he knows within the scope of the Kovel agreement. And what I'm referring to here is the original accountant. Remember that only the Kovel accountant is protected by the attorney-client privilege. Up until the time that the accountant is engaged by the attorney and the Kovel engagement agreement is inked and signed, the original preparer only enjoys a accountant-client privilege with his client, which is a very watered down privilege, if at all. Keep in mind that the work papers, for example, of the accountant in an accountant-client privilege are fully discoverable, and the government need only drop a summons on the accountant before the accountant must have to turn over that information. So you want to protect and insulate this new accountant to the fullest extent possible, and you do that by hiring an independent accountant and having the attorney bring them in under a Kovel engagement. That gives the Kovel accountant the same strong privilege that the attorney enjoys with his or her client. Moreover, using the existing accountant requires that additional steps be taken to ensure that the information garnered within the scope of the Kovel Agreement is clearly separate from the information learned before the Kovel Agreement was executed. And this, as we've already discussed, can become tedious and arduous. How do we know what information was gathered pre-Kovel engagement signing versus what information was gathered post Kovel engagement signing, keeping in mind that only the information obtained by the Kovel accountant on the day that the Kovel engagement was signed is subject to the heightened attorney-client privilege, whereas all other information obtained before that point is protected only by the flimsy accountant-client privilege. And, again, trying to put your finger on what information was obtained when is a logistical nightmare and gives the government an incredible amount of latitude to argue that the documents were obtained earlier and post Kovel engagement signing rather than post Kovel engagement signing. For these reasons, start out fresh and hire an independent accountant from the get-go. IRS Appeals. We're going to talk about a couple of topics here that are specific to IRS Appeals. We're going to discuss the role of appeals, hazards of litigation, what does appeals consider, what issues can the taxpayer raise. We'll do an overview of the appeals process, talk about the role of the appeals team manager, discuss some questions that come up frequently. For example, what if an agreement is reached? What if an agreement is not reached? We'll discuss the independence of appeals and ex parte, and then end with non-docketed versus docketed cases. We're going to take a short break here. All right, here we go with the role of appeals. The legal requirements are found in the Internal Revenue Code, Treasury regulations, revenue rulings, revenue procedures, and court decisions that consider tax disputes. Keep in mind, what we're talking about here is not a judge with a robe sitting in a courtroom, or a three-judge panel, which you would typically find in a court of appeals. Or in that case, it could even be a single judge if you're in a state court of appeals. What we're talking about here is the IRS Appeals Division of the IRS, which is very much akin to a mediator in a civil dispute. There is in New Jersey court-mandated mediation where parties that have a civil controversy, perhaps arising out of a slip and fall or something of that nature. It could even involve a contract, breach of contract. They're obligated to mediate the issue before the case gets docketed for trial. And so what we're talking about here is on the tax end of things, we have something similar to mediation. And this is what is known as the Appeals Division of the IRS that attempts to mediate matters before they are litigated in U.S. tax court. So we just discussed the legal requirements. An appeals employee must consider the following issues. Number one, did compliance follow all required legal and administrative procedures? Second, they must consider issues raised by the taxpayer, such as whether the notice of federal tax lien is appropriate and whether there are appropriate collections actions. Third, the appeals officer must balance the need for efficient tax collection with the taxpayer's concerns about the intrusiveness of the collection action. Now, what makes the appeals function distinct from the examination function? Well, appeals is uniquely positioned to recommend a resolution that is somewhere between fully sustaining or fully conceding the examiner's proposals based on the uncertainty of the outcome if the case was considered by a court of law. So again, this is language that comes directly out of the manual. Appeals basically can recommend a resolution to the case that might be somewhere between fully sustaining the examiner's proposals or fully conceding the examiner's proposals based on the uncertainty of the outcome of the case if it was considered by a court of law. So what this means is that the IRS appeals officer can actually take into consideration the hazards of litigation in determining whether to make some concessions and throw the taxpayer a bone, so to speak, in resolving the case. Now, it's important here to compare what examination does to what appeals has been granted the authority to do. Keep in mind, appeals, their mandate is to be fair and impartial. And I realize that that's hard to take. It's hard to accept, on its face, because appeals is a division of the IRS. But by fair and impartial, what the IRS, is referring to here is that it should reflect mutual concessions, be based on the relative strength of positions, and take into consideration where litigation uncertainty exists when it comes to making concessions. Now, in evaluating the hazards of litigation, appeals considers both factual hazards and legal hazards. So for factual hazards, this is when there is uncertainty as to the court's findings of facts. Factual hazards exist when there's either incomplete evidence or conflicting evidence. This evidence could either be records or testimony of witnesses. Here's a quick and dirty example for factual hazards. The taxpayer may be claiming actual mileage as a business expense. The taxpayer presents documentary evidence that establishes an odometer reading at the beginning and end of the year. These numbers determine total mileage driven throughout the year. Yet during the examination process, the taxpayer tells the examiner that he lost the business mileage log, so the evidence needed to support business mileage deduction was incomplete. Conflicting evidence comes into play when the testimony of witnesses does not corroborate the same story. Now, if we just look at that example, we have a situation where the taxpayer has presented documentary evidence that establishes what the odometer read at the beginning and what the odometer read at the end of the year. Presumably, these numbers will determine the total mileage driven throughout the year. And so what happened was, unfortunately, during the examination process, the taxpayer lost this business mileage log and was unable to produce it to the examiner. And so the examiner was not willing to take hook, line, and sinker the taxpayer at his word, and was unwilling to accept any representation made by the taxpayer as to the total mileage driven without proof to confirm and back up the statements made. And as a result, the examiner denied the mileage deduction because there was insufficient evidence to corroborate it. Well, later on in the process, or when we get before the appeals officer, lo and behold, the taxpayer has found the mileage log and is now possesses concrete evidence to prove what the odometer reading was at the beginning and what it was at the end of the year. And based on that, the appeals officer can extrapolate what the total mileage driven throughout the year was. And so there is now corroborating evidence or confirming information that is new and that will allow the appeals officer to look at this claim and to give it more merit and very likely find in the taxpayer's favor. So this would be a classic example of factual hazards where the appeals officer would rather not reject the taxpayer's argument because it will not be a weighty argument for the IRS chief counsel's to make at a trial, since there now is corroborative information to back up the claims made by the taxpayer. As a result, the independent appeals officer is likely to rule in favor of the taxpayer and grant the business mileage deduction that was previously denied by the examiner, and perhaps the taxpayer will be satisfied with this resolution, and a resolution will result without the case having to proceed to trial. Legal hazards. What we're talking about when it comes to legal hazards is uncertainty as to how the court would apply or interpret law. Legal hazards exist when there is conflicting case law, absence of legal precedent, conflict between the IRS's position on an issue and court decisions, ambiguity in the applicable statute or regulation, or conflicting law. All of these are par for the course for the appeals officer to take into consideration when deciding whether to affirm the decision of the examiner or to make some concessions, and out of fear of not knowing how the court is going to come down on the issue. So again, All of these can be taken into consideration. Conflicting case law, absence of legal precedent. Of course, if there is case law specifically on the point and it is pro-government, then the appeals officer is likely going to reject the claim made by the taxpayer and side with the IRS revenue officer. But if there's conflicting case law, absence of legal precedent, that leaves a lot of doubt as to how the court would rule, then perhaps the appeals officer, perhaps this uncertainty will result in the appeals officer making some concessions, throwing the taxpayer a bone, and and having the taxpayer agree to the resolution. What does appeals consider? Well, there are three main issues here. First, did compliance follow all required legal and administrative procedures? For example, was a notice of intent to levy issued in accordance with the law? Did the IRS notify the taxpayer as required that notice of lien was going to be filed? Did the IRS issue the notice of hearing timely? Second, the appeals employee will consider all issues raised by the taxpayer with the exception of moral, religious, or constitutional objections. So any taxpayer protester arguments are going to be thrown out the window, or to use the expression, they're going to be thrown out with the bathwater. They will not be considered by the appeals employee. Three, the appeals employee will balance the need for efficient tax collection with the taxpayer's legitimate concerns about the intrusiveness of the proposed collection action. And again, that comes right out of the manual, this balancing of the need for efficient tax collection with the taxpayer's legitimate concerns about the intrusiveness of the proposed collection action. That's continuously what the appeals employee will come back to when making this their decision. What issues can the taxpayer raise? Well, first, any relevant issue relating to the unpaid tax or the proposed levy, including the appropriate spousal defenses, innocent spouse, for example. Appeals will only consider challenges to liability if the taxpayer, 1, has not received a notice of deficiency, or 2, otherwise had an earlier opportunity to dispute the liability before appeals. All right, so very important here. Any taxpayer wishing to challenge the underlying liability will be barred from doing so before IRS appeals unless the taxpayer has not received a notice of deficiency or otherwise had an earlier opportunity to dispute the liability. So very, 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 very important to recognize these exceptions, because more times than not, the taxpayer wants to challenge the underlying liability. But again, this can only happen before appeals, that is, if the taxpayer has not received a notice of deficiency or 2, had an earlier opportunity to dispute the liability before the case arrived at appeals. For example, if the taxpayer received a letter 1153 informing him of a proposed trust fund recovery penalty and did not appeal the proposal at that time, appeals does not have the authority to consider whether the taxpayer is liable for the penalty during the collection due process hearing. What other issues can the taxpayer raise? A second challenge that the taxpayer can mount is to the appropriateness of the collection actions. And the third issue that the taxpayer can raise are offers for collection alternatives. So IRC, or Internal Revenue Code Section 6330, requires appeals to evaluate collection alternatives offered by the taxpayer, such as posting of bond, installment agreements, offers in compromise, and substitution of other assets. A basic requirement before appeals will consider alternatives is that the taxpayer has filed all required tax returns prior to the hearing. Now, it's important to note here that while appeals is considering the case, interest continues to add up on any unpaid balance that the taxpayer may owe. So, while this appeals process is going on, interest continues to add up on any unpaid balance. The mere fact that the case is before appeals does not in any way negate or prevent the accruing of interest. Overview of the appeals process. The sources of cases. Appeals basically receives cases from any one of four divisions, from LMSB to SBSE to WNI and TEGE. These are basically the acronyms for the main divisions of the IRS. And so essentially, appeals can receive cases from basically any one of the four main divisions of the IRS, from business-related audit divisions to small business to wages and investments to your typical individual taxpayer who is filed. Generally, disputed tax cases come from the compliance function within these divisions, which by compliance I'm referring to examination or collection. Within each function, field offices or campus offices work the entire spectrum of cases relating to that spectrum. Therefore, appeals receives cases from both field and campus sites. Now, how does a taxpayer request an appeal? Well, that depends on the source of dispute. Since appeals is separate and independent from compliance, the taxpayer must first request an appeal to the office that proposed the original determination or specific collection action. Appeals will receive a complete administrative case file that includes the taxpayer's position and the government's position. Second, in tax disputes generated as a result of an examination of the taxpayer's tax return, the taxpayer must submit a written request to the examination office that reviewed their return. In cases where the dispute is less than $25,000, no formal protest is required. For collection issues, it depends on the type of collection dispute. So to back up to number two, in tax disputes that are generated as a result of an examination of the taxpayer's tax return, the taxpayer must submit a written request, which is otherwise known as a protest, to the examination office that reviewed the taxpayer's return. In cases where the dispute is less than $25,000, no formal protest is required. And then finally, when we're dealing with collection issues, it depends on the type of collection dispute. Now for commitments and expectations. The IRS Appeals is committed to a number of goals. First, to explain to the taxpayer their appeal rights in the appeals process. Second, to listen to the taxpayer's concerns. Third, to be courteous and professional. Fourth, to be responsive and allow a reasonable amount of time to respond to any request for information. And finally, to be fair and impartial. At the same time, the IRS Appeals Division has expectations, and those expectations consist of a laundry list of items. First, to listen to the appeals explanation of the taxpayer's appeal rights and the appeals process. So it's expected by the appeals officer that the taxpayer will listen to the appeals officer's explanation of his or her appeal rights and the appeals process. Second expectation is that the taxpayer gives appeals a statement as to how They understand the facts and the law, listing all issues with which they disagree and why. Third, expectation is that the taxpayer will give appeals any additional information or documentation that will help their case. The fourth expectation is that the taxpayer will inform appeals when and how they think the case should be resolved. And the fifth expectation that IRS Appeals holds for the taxpayers that come before it is that the taxpayers will advise appeals or let appeals know the best time for them to be contacted. Conferencing options. Appeals considers the appeals consideration of tax disputes is designed to be an informal administrative process, no different than any other mediation. There are several conferencing options. They range from written correspondence to telephone correspondence to face-to-face conference. Typically, conference calls are via telephone are the standard when it comes to the appeals officer mediating these disputes. What is the role of the appeals team manager? Well, the appeals team manager approves the final outcome of the case. The appeals employee will make a recommendation to the appeals team manager, including whether or not an agreement has been reached. The appeals team manager will review the file and approve the case if the settlement is appropriate, or return it to the appeals officer if additional work or consideration is required. So what happens if an agreement is reached? If an agreement is reached and the client doesn't owe anything or a refund is due, the tax preparer basically has nothing more to do. If there is a refund, the campus will send it directly to the client. If the taxpayer owes some amount, then they have a number of different options. Could be had to make the payment. The taxpayer can pay a few different ways. First, and I guess this is probably the easiest way for the matter to be closed, is for the taxpayer to simply pay the full amount outright that is due. But in cases where the taxpayer can't pay the full amount at once, he or she may qualify for a payment plan. For example, if the total amount owed is under $25,000, the taxpayer may qualify for a 60-month payment plan, and usually does when the total amount owed is under $25,000. In fact, it's as simple these days as going online and requesting the 60-month payment plan. It's more often than not granted. And as I said, if the total amount is under $25,000, there's really an automatic qualification for a 60-month payment plan. If the taxpayer doubts that he can afford to pay the full amount even under a payment plan, and he has filed all of the required tax returns, he can consider submitting an offer in compromise. An offer in compromise basically means making a proposal to the IRS for a lesser amount than what has been determined to be due. If successful, the taxpayer can pay this lesser amount than what he owes. I will caution you that an offer in compromise does require a substantial amount of paperwork that requires a taxpayer to open up his or her financial kimono and disclose to the IRS any and all assets and property that he or she owns. In many cases, it's so intrusive that the taxpayer rather not complete the paperwork and in some cases pay the full amount due rather than disclosing to the IRS what could otherwise be private matters that they would rather not get into. But keep in mind that while an offer in compromise could be be a blessing, it can it does require the completion of this very detailed paperwork that could reveal more than what the taxpayer has already revealed. And as a result, a lot of taxpayers prefer just to pay the amount outright than to fill out this paperwork and open up the financial kimono. If the taxpayer does not reach an agreement with appeals, the appeals officer will inform the taxpayer as to any further options he or she might have. What if an agreement is not reached? If the taxpayer requests an appeals conference but the parties don't come to an agreement, the IRS will send the taxpayer a notice of deficiency, which is known as the 90-day letter. A notice of deficiency provides the taxpayer with two options. First, pay the asserted deficiency and follow the refund procedures if you so choose, or petition the tax court to contest the claim deficiency within 90 days of the date the notice of deficiency was mailed. Those are the two options that the taxpayer has if an agreement is not reached before IRS appeals and the notice of deficiency is issued. Now, the mailing of the notice of deficiency begins a period during which the IRS is prohibited from assessing tax. Why? Because the taxpayer enjoys the absolute right to file a petition to the U.S. tax court. And that's what bars the IRS from assessing the tax. Because if it assesses the tax, then we have essentially reached the end game of this process, and yet that would prohibit the taxpayer from exercising his or her due process rights to file a petition and have the case be heard in tax court. So as a result, during this 90-day period, the IRS is prohibited from assessing tax. If the taxpayer petitions the tax court, the prohibited period continues until the tax court's decision is final. So let's talk about the independence of appeals and ex parte. The mission of IRS appeals is to resolve tax controversies without litigation on a basis that is fair and impartial to both the government and the taxpayer. So the question here becomes one of, it's a rhetorical question. How can appeals demonstrate it is fair and impartial to both parties to the tax dispute when, at the end of the day, an IRS appeals officer is an employee of the IRS? Well, the integrity of appeals depends on its ability to remain fair and impartial to both parties. If it can't do that, then all faith and confidence will be lost. And, that's when the taxpayer, will be very cynical and skeptical about whether his or her claim is being viewed independently by the appeals officer. And in many cases, it's, there are going to be taxpayers that can't get past the idea that the appeals officer is an employee of the IRS and will forever believe that the appeals officer has got it out for him and is on the side of the IRS, and that his or her claim is not being given the fair and impartial look at that the IRS appeals officer is projecting it will be. So Congress recognized the need for appeals independence when it passed the Restructuring and Reform Act of 1998. We talked about this a little bit earlier. And so what they tried to do is give the public some faith and confidence in the independence of appeals through the language of the Restructuring and Reform Act. Section 1001 requires the IRS commissioner to develop a plan to reorganize the IRS. Section A4 devised a plan to ensure an independent appeals function within the IRS, a plan that prohibits ex parte communication between appeals employees and other IRS employees to the extent that such communications compromise the independence of the appeals employee. So essentially, ex parte communications between the appeals employee and the IRS revenue agent is barred. So again, that's very, very, very important. That's why Congress included that prohibition in the Restructuring and Reform Act. They didn't want the appearance that there was stuff going on privately and behind the scenes between the examiner and the IRS appeals officer. They didn't want any of that, to devolve into, a discussion where the two parties were plotting against the taxpayer. And so ex parte communications between the appeals employees and the examiner are strictly prohibited. And the caveat here is to the extent that these communications appears to compromise the independence of the appeals employee. And I can't fathom a situation or a scenario where any ex parte communication whatsoever between an appeals employee and an IRS examiner would be kosher under Section A4. And so what came about as a result of this was Revenue Procedure 2000-43, where it describes what ex parte communications are and what is prohibited and what is allowed. So how do the ex parte rules affect how appeals communicates with the compliance function or with the examiner? First, there can be no discussions about substantive case issues between appeals and compliance without inviting the taxpayer to participate. And this is not just limited to oral communications. It's also broadly includes written communications between the appeals officer and the examiner. Second, if the taxpayer provides new information to appeals, appeals asks the examiner for their opinion in writing and shares their comments with the taxpayer. When there's need for further clarification from the examiner, the appeals officer may contact the taxpayer and even invite the taxpayer to participate in a conference call or meeting with them about the new information. Third, this law includes discussions with IRS Chief Counsel attorneys about non-docketed cases. Very important to note this. It's not just limited to discussions between the appeals officer and the revenue agent. It broadly includes discussions that could take place between the appeals officer and an attorney from IRS Chief Counsel's office about non-docketed cases. If the appeals officer needs advice about an issue, it must be given by an IRS Chief Counsel attorney who did not provide advice to the compliance employee, namely the auditor or the examiner. Okay, so very important that whenever the appeals officer has to consult with an attorney from IRS Chief Counsel's office about an issue arising out of this dispute, the appeals officer has to, and where the appeals officer needs advice about the issue from the attorney from IRS Chief Counsel office, it has to go to IRS Chief Counsel's attorney, and the attorney that's consulted with cannot be one who has provided advice to the compliance attorney. Very important, because if the appeals officer consults an attorney from IRS Chief Counsel's office who's already been consulted by the examiner, then that attorney from IRS Chief Counsel's office is considered tainted and could not be and cannot be gone to for advice by the appeals officer. Instead, the appeals officer has to consult a brand new attorney from IRS Chief Counsel's office. Fourth, if an appeals employee believes it's necessary to talk to a previous IRS Chief Counsel attorney regarding an issue, he or she must give notice to the taxpayer or the taxpayer's representative so that they in turn have an opportunity to participate in that discussion. So to the extent that the IRS appeals employee believes it's necessary to talk to a previous IRS Chief Counsel attorney that had previously been consulted by the examiner, then the appeals officer must notice the taxpayer or representative that they are going to be consulting with an IRS Chief Counsel attorney who previously gave advice to the examiner, and that in turn gives the taxpayer or the taxpayer's representative the opportunity to participate in the forthcoming discussion between the appeals employee and the attorney from IRS Chief Counsel's office. If the appeals officer goes to a brand new attorney from IRS Chief Counsel's office that never had any previous discussions with the original auditor, then there is no obligation on the appeals employee's behalf to notice the taxpayer or his representative. Exceptions to the ex parte rule. The administrative file itself, developed by compliance and forwarded to appeals, does not violate ex parte rules, and that's typically the procedure that takes effect. The examiner forwards their administrative file to the appeals officer, and that direct filing of the file with the appeals officer does not violate ex parte rules. Since the administrative file contains a proposed determination and taxpayer's protest, it merely sets forth the boundaries of the dispute between the taxpayer and the IRS and forms the basis for appeals to assume jurisdiction. So that's the justification for the file, not triggering or being rather an exception to the ex parte rule. Second, where contact with compliance relates to administrative, ministerial, or procedural matters, that does not come within the ex parte rule and is a carved out exception. Again, where contact with compliance relates to administrative, ministerial, or procedural matters, there is no ex parte rule that's in effect, and that's a carved out exception. And the final exception to the ex parte rule is where the communication is needed, the third exception to the ex parte rule is where the communication is needed to understand an individual's handwriting. If the taxpayer's representative has been offered the opportunity to participate in a discussion between appeals and compliance, but unnecessarily delays responding to that opportunity, the ex parte rules will not apply. Delay, however, must be beyond a reasonable amount of time. So the scenario is one where the appeals officer invites the taxpayer or his representative to participate in a discussion between appeals and the examiner. But for whatever reason, the taxpayer or his representative unnecessarily delays responding and ignores the opportunity to do so. In that case, then the appeals officer can carry on with his contact with the appeals officer, with the examining officer without having to include the taxpayer or his representative. But it's important here to understand that the delay must be beyond a reasonable amount of time. It can't be 24 hours or 48 hours. That's too little time. The taxpayer or his representative must be given a reasonable amount of time to respond before the appeals officer has this ex parte discussion with the examiner. Do the ex parte provisions change the appeals policy regarding raising new issues? The simple answer is no. Appeals still has the right to raise new issues, but it doesn't do so often. New issues are never raised casually or haphazardly by an appeals employee, and they're never raised for bargaining purposes. To raise a new issue, it must be substantial, and its effect must it must have a potential effect on the tax liability, and that potential effect must be material. By material here, what we're talking about is having real importance and great consequence. Now, it is important to distinguish between a non-docketed versus a non-docketed case. Here we're going to stop and take a short break before discussing this. Okay, non-docketed versus docketed cases. Let's distinguish between the two. A non-docketed case is a case that is made on what's called a protest basis in response to a 30-day letter. So basically, the taxpayer files what's called a protest in response to a 30-day letter, which we discussed earlier is known as a revenue agent's report. This means that no court has jurisdiction over the taxpayer's dispute, and that's why it's referred to as non-docketed. Now, by contrast, we have a docketed case. Let's suppose that the taxpayer petitions the United States Tax Court without having had a conference with the appeals division. In that case, the case is considered to be in docketed status. Why? For the simple reason that the taxpayer filed a petition with the tax court. That's basically the key to getting into the tax court, the filing of a petition. And by virtue of having filed that petition, the case gets docketed in the tax court. And its status is considered to be that of a docketed status. Now, if appropriate, an attorney from IRS Chief Counsel may forward the case to appeals for the purpose of reaching a negotiated settlement prior to the case being heard by tax court. So, notwithstanding the fact that the taxpayer filed a petition and that the case has been docketed in tax court, the attorney from IRS Chief Counsel still reserves the right to kick the case back to appeals so that a potential settlement can be reached prior to the case being litigated before the tax court judge. So, it's very important to recognize that the taxpayer does have the right to bypass the appeals and go right to tax court by filing the petition, because the petition is the key to getting into tax court. But remember, there has to be a notice of deficiency filed in order for the taxpayer to file the petition in tax court in the first place. But going back a step here, the taxpayer can basically do nothing and not respond to the initial letter and not file a protest, but instead file the petition with the tax court. However, it's important for the taxpayer to recognize that while they might want to bypass appeals altogether because perhaps they think that the appeals officer is not going to be fair and impartial and go right straight to tax court, they need to still understand that the attorney from IRS Chief Counsel's office may label the case as one that could reach a negotiated settlement if it's heard by an appeals officer. And as a result, the attorney from IRS Chief Counsel's office may forward the case to appeals for exactly that purpose. So while the taxpayer may have tried to circumvent the appeals mediation process altogether by filing the petition and not filing a protest before IRS appeals, he or she may find themselves right back in appeals if the IRS Chief Counsel attorney finds the case to be one that could potentially be settled before an IRS appeals officer. And in that case, the taxpayer would have to go through the appeals process before any litigation takes place in tax court, notwithstanding the fact that the taxpayer filed the petition in tax court and that the case has been docketed. However, keep in mind that if appeals and the taxpayer are unable to reach a negotiated settlement, then a court of law, namely the tax court, will ultimately decide the taxpayer's dispute. Types of non-docketed cases. First, We have cases where the examination function has issued a 30-day letter accompanied by an examiner's report outlining the proposed adjustments resulting in an increase to the taxpayer's tax liability. The taxpayer has 30 days in which to agree to the proposed adjustments or to request an appeal to the proposed adjustments. Second type of non-docketed case, where a claim has been denied for refund or abatement of unpaid tax. Now, tax disputes from taxpayers who requested an audit reconsideration. If the taxpayer's request for an audit reconsideration is granted, yet examination does not reduce tax liability in full or in part, the taxpayer can have the dispute considered by appeals. That's another type of non-docketed case. Note well that the taxpayer has a right to appeal an adverse U.S. tax court decision to the Circuit Court of Appeals for the circuit within which the taxpayer resided at the time he filed the petition. So we talked about this earlier. Very simply, if the taxpayer has been ruled against in the U.S. tax court and wishes to take the matter to a higher court and to appeal the tax court judge's decision, then the taxpayer has to appeal to the circuit where he resided at the time he filed the petition. If he lived in Florida at the time he filed the petition, but now he's living in New Jersey, he would have to file the petition in the Ninth Circuit Court of Appeals, which is the circuit that encompasses Florida. Just because he's now living in New Jersey doesn't mean that he gets to appeal the judge's decision in the Third Circuit Court of Appeals, because what defines where the circuit, what defines where the appeal will take place is where the taxpayer was living at the time he filed the petition, even if he's now living in a different location and a different circuit entirely. Transfer and conference procedure changes in appeals. Appeals has implemented changes to its case transfer and conference procedures. Previously, in cases where a face-to-face conference was requested, appeals allowed automatic transfer from the campus service center to field offices. After reviewing this procedure, the IRS discovered the taxpayers often requested a case transfer where a campus employee could have resolved the case. In addition, there were added costs for shipping as well as a delay in case resolution. Another consideration was that many of these transferred cases were ultimately resolved by a telephone conference. The change is that appeals will not transfer cases based only upon the taxpayer's request and will consider a number of factors before an in-person conference is granted. In-person conferences these days are very few and far between. The hearing officer makes the initial determination to grant an in-person conference, and the appeals team manager will make the final decision. The Internal Revenue Manual has actually been updated to reflect these changes. IRS collection methods. Okay, so an assessment has been made, and the IRS wants its money, but the taxpayer doesn't have the money to pay the IRS. The IRS can collect amounts owed in several ways. One of the first ways is an installment agreement. Basically, an installment agreement allows a taxpayer to pay the amount that he owes or she owes over a specific period of time. So it's not a reduced amount. It's the exact amount that the IRS has determined the taxpayer must pay. However, the IRS is allowing the taxpayer in an installment agreement to pay that amount over a period of time, typically in what's called monthly installment payments. Keep in mind that an installment agreement does not forestall the accruing of interest during the period. So before the taxpayer leaves your office shouting for joy, it's important to emphasize to him that the accrual of interest will continue throughout the period of the installment agreement. I've seen installment agreements in 3-month intervals. I've seen installment agreements in 1-year intervals. I've seen installment agreements in 36-month intervals. I've seen installment agreements in 60-month intervals. Now, how a second way for the IRS to collect is through an offer in compromise. Now, an offer in compromise differs from an installment agreement in the sense that if accepted by the IRS, it allows a taxpayer to pay a lesser amount to settle the case. So, unlike an installment agreement where the taxpayer has to pay the exact amount due, in an offer in compromise, the IRS allows the taxpayer to pay a lesser amount than he or she otherwise has to pay in order to settle the case. Typically, an offer in compromise is paid in in one payment, and that's usually the impetus or the motivation for the taxpayer to make it in one payment. The fact that it has been the liability, that is, has been compromised from what it otherwise should be. That gives the taxpayer every incentive in the world to sell assets, to borrow, do whatever is necessary to make the payment in one payment. The fact that it's a lesser amount than is otherwise being required. Levy action. Well, a levy is legal seizure of property such as cash, wages, or bank accounts to satisfy a tax debt. And that's the third way that the IRS can collect amounts owed. Filing a notice of federal tax lien. Basically, a lien gives the government a claim to property as security or payment for a tax debt. The notice of federal tax lien has to be made by the IRS and notifies the public that the government has such a claim. So a lien is usually, not usually, it must be accompanied by a notice to the taxpayer of the lien. And it's also filed in the registrar's office, notifying the public that the government has such a claim. Now, during the appeals consideration, now we're dealing with appeals right now, what happens with the collection action? Well, as you might imagine, levy action is suspended during the period of time that appeals is considering the taxpayer's request, timely request, that is, for a collection due process hearing relating to a notice of intent to levy. So if we are dealing with collection action before an appeals officer, levy action would be suspended during the period of time that appeals is considering the taxpayer's timely request. And that's because it's only fair to say that, why would the IRS be able to proceed forward with levying against the taxpayer's property when the consideration of whether when the consideration for collection due process is being reviewed at that precise moment by the appeals officer. It would be counterintuitive to say that appeals is considering the taxpayer's request for a collection due process hearing, but levy action is going to begin. It's two competing things going on at one time, and the whole purpose of the hearing before the appeals officer relates in essence to whether levy action is even warranted in the first place. So how, pray tell, could the IRS begin levy action while the matter is pending before IRS Appeals? Now, by contrast, in equivalent hearing cases, collection, believe it or not, can move forward on levy if the IRS determines that collection of tax is in jeopardy. So an equivalent hearing differs from a collection due process hearing, and it affords lesser rights in the sense that at an equivalent hearing, collection can move forward on the levy if and only if the IRS determines that collection of tax is in jeopardy. So we have now reached the end of this presentation. It's been my pleasure to discuss this very robust area of civil tax controversies with you. I encourage you to reach out for me if you have any follow-up questions from this presentation. I am available on social media, LinkedIn specifically, if you want to shoot me a note, or you can feel free to email me at my email address, which is M as in Michael, J as in James, my last name DeBliss, D as in David, E as in Edward, B as in boy, L-I-S at deblisslaw.com. You're certainly welcome and free to peruse any of the blogs that are on my website, and you can find them on my website at www.deblisslaw.com.